Ladies and gentlemen, please take your seats. We are about to begin. Ladies and gentlemen, please take your seats. Our program will begin in 2 minutes.
Ladies and gentlemen, please welcome Scott McDonald, President and CEO of the Advertising Research Foundation.
Okay, coming into the home stretch here. So for those who are still getting a drink at the bar, I'll ask you to hush so we can get going and not, we've been so on time throughout most of the conference here. Would hate to blow that now. When putting together a program for this conference, or for any conference, I usually try to think of a few things that seem to be under-discussed in our industry. The example from yesterday was blockchain and its potential application to digital supply chain corruption. One of the things that I continue to be very nervous about the state of readiness of American companies has to do with the emerging set of data privacy regulations that have been developing in the European Union and their effect. Now, many companies tend to think that because they do business here, they may not have offices in Europe, that somehow it doesn't affect them. But given the global interconnectedness that all of us and all of our companies encounter with our customer bases, it's inconceivable to me that these regulations don't apply to most American companies. So reached out to an expert in this field, Reid Freeman, who is partner at WilmerHale, one of the leading law practices in Washington, D.C. It's actually the firm from which Robert Mueller was just resigned from to become special prosecutor. Reid is the co-chair of WilmerHale's Cybersecurity, Privacy, and Communications Practice Group. He serves as lead counsel in Federal Trade Commission and state advertising, privacy, and data security investigations and negotiations, having handled scores of such matters. He is perennially ranked by Chambers and Legal 500 as one of the country's leading practitioners in the privacy and data security area. So please welcome Reid Freeman.
We made a promise, we swore we'd always remember. No retreat, baby, no surrender.
Put the lawyer last, right? We're used to that. It was kind of interesting. Bob Mueller, former director of the FBI, was in my group actually. You can imagine the meetings that we'd have, and Bob, you need to get your hours up and put your time in on time and get your bills out. It was very awkward. But the latest I read in the newspaper was that Trump might pull a Nixon and do a midnight massacre. So maybe we'll get Bob back. He's terrific. So I'm here to talk about the GDPR, the Europe's General Data Privacy Regulation, and a little bit about the e-privacy regulation, which is on the way, and to engage in a little Q&A. So, without further ado, let's go on. We're going to talk about the background of the GDPR, its application to advertising, consent, profiling, and direct marketing, other requirements of the GDPR. There are many. If anybody reads the entire GDPR from beginning to end in one sitting and can answer 10 questions from me and get them all right, I'll give you $100. But you're on your honor. It can't be done. Fines, guidance, update on the e-privacy directive being turned into a regulation, and so forth. So let's give some background. The GDPR is a new form of regulation in Europe. They had the Data Privacy Directive. That was an implementing piece of legislation. It had no effect in and of itself. The European Commission Union issued it. The member states implemented it, of course, naturally, all differently, and they policed it differently and interpreted it differently, and finally Europe said, enough, we're going to have a regulation. A regulation has direct effect in every member state, and with very few exceptions, cannot be modified by the member states. So this is one law that applies in all member states. Hard to tell what, maybe the UK is going to come back, I don't know, but right now it's 28. It's gonna, so bullet point number one, it has extraterritorial effect. It applies to you if you're processing information of somebody in Europe. You want to know what processing means? Any operation or set of operations performed on personal data collection, including collection, organization, storage, adaptation, or alteration, use, or disclosure. You touch it, you process it. If it's a European residence data, the GDPR applies to you wherever you sit. And it's fines. The definition of personal data is exceptionally broad. We think of personal data here in the United States as name and address and things of the email address and things of that sort. Not so increasingly in the US, and certainly not so in Europe, where personal data includes things that are capable of identifying an individual, even if not directly, and they include cookie IDs, mobile IDs, IP addresses, location data, device fingerprinting, stat IDs, unless it's de-identified. And all you need to know about that is it's virtually impossible to de-identify data and convince the Europeans that you've done so. That's what we just talked about. All right, I'm going to get better at this. We'll skip a slide because we just kind of did 2 in 1 and go to consent and advertising. All right. This is confusing because the general data privacy regulation applies to advertising, but right behind it is going to be an e-privacy regulation that's going to apply to all electronic communications, including advertising, and it's going to require consent, and consent means written in blood and provable, and so the GDPR is done, it's negotiated, it takes effect May 25th, 2018, less than a year. The e-privacy regulation is undergoing negotiations now, but it will overlap to some extent. So if you are going to process data under the GDPR, you have to have a lawful process for advertising, tracking, marketing, profiling, automated decision-making, etc. There are 2 options available. One is consent, and the other is that the processing is necessary for the purpose of the legitimate interest of the controller or third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data. So it's a balancing test, a legitimate interest, your legitimate interest versus the individual's data interest. Guess who wins in Europe every time? So if you are going to advertise in Europe, process personal data for advertising purposes, you can use consent or a legitimate interest. If you use a legitimate interest, you better document why you meet the balancing test and be able to prove it, because it's the regulators are going to be highly, highly, highly skeptical. They're going to be expecting consent. So consent, what is consent? Any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement of clear affirmative action, signifies agreement to the processing of personal data. So, unchecked box, clearly and prominently put in front of consumers, where the notice describes the full amount of what you intend to do with the data, and the consumer checks the box and says, I agree, and you record it and save it because it's part of your record-keeping requirements we'll get to. Interestingly, consent must be specific to every single data processing you do. This is seriatim. You cannot get consent for a list of things. You've got to go one by one by one by one by one. It is something that is probably going to be revisited because it is going to annoy everybody, you and the consumers. You need to demonstrate, a big part of the GDPR is record keeping of your compliance with the GDPR. So you need to demonstrate and be able to show upon request that data that you've gotten consent. You can't condition services on consent to use data for a particular purpose. And you have to have a higher level of consent, although we don't yet know what it is because we don't have guidance yet from the relevant European bodies for sensitive data. So what's the big deal here? The big deal is you need to get direct, affirmative, opt-in consent from the consumers. First parties can do that. They can. Then people might not consent, but they can get it. Third parties will have to put it in a contract and get publishers and others that they work with to get the consent for them and document that, and nobody's going to want to do that. So this is a problem for third parties in the ad ecosystem, and it's going to be a much bigger problem with the e-privacy regulation. Profiling and automated decision making and direct marketing. This is so profiling is basically what you do and what marketers do. It's defined to say any form of automated processing of personal data consisting of the use of the data to evaluate personal aspects relating to a person, to predict aspects concerning that person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location. Segments. Creation of segments is profiling. Interestingly enough, the Europeans hate profiling, but for whatever reason, and I don't know why, profiling is a notice and opt-out. Now, the notice needs to be a sledgehammer to the face multiple times, and the consumer has to be offered an opportunity to opt out, and that opt-out has to work, and the opt-out has to be an ongoing opportunity. But interestingly enough, profiling is not an opt-in activity. It's an opt-out activity. Opt-out rights, again, have to be brought explicitly to the attention of the data subject and presented clearly and separately. And you really need to explain what you're doing with respect to profiling and decisions that are made on an automated basis regarding consumers. And then you need to document it and save it because when the regulators come calling, they're going to ask for all these documents. And failure to have a document alone, whether you did it or not, is in and of itself a violation of up to 2% of your gross annual, what they call in Europe, turnover, or your revenue. Not profits, revenue, up to 2%. So other requirements under the General Data Protection Regulations are a data protection officer if you regularly and systematically monitor data subjects on a large scale. Anyone here do that? I think maybe some. Data privacy impact assessments are mandatory for organizations where there's a high risk to the rights of the data subject. So the Europeans think that profiling people presents a high risk to the privacy of data subjects, and therefore a data privacy impact assessment is mandatory. The data subjects, people in Europe, have the right to access, rectify, erase, restrict, object, and also interestingly, have a right of data portability, which is kind of like our telephone number portability that we have here, but the operators in Europe are required to be able to hand over your data in a format that is usable on another platform so that they can't monopolize your data on that platform. So data transfers, I'll just touch on this briefly. There are three mechanisms. Two of them are under attack. We expect more guidance from the regulators in Europe soon. And I think later on we'll talk about the Privacy Shield, but right now the Privacy Shield is a viable mechanism to transfer data of European residents from the EU to the US. The GDPR also, for once, catches up with US requirements. Now, they exported privacy to us. We exported data security to them. They're just catching up. So you all have been living under 48 jurisdictional notice requirements and the FTC's reasonable security requirement. This is the first time under the GDPR where there's a substantive requirement to have adequate security and to document it. And there's a procedural requirement to notify data subjects and to notify your regulator of a breach within 72 hours. So you have to notify your supervisory authority that you pick. I'm skipping, I mean, to do the GDPR it takes about 3 days, so I'm skipping over a lot. But ultimately you have a single regulator, and ultimately that's not actually true. But theoretically you have a single regulator, and you have to notify that regulator within 72 hours of a breach that is likely to result in a risk to the rights and freedoms of individuals. I can tell you I've done dozens and hundreds of breaches. Nobody knows anything after 72 hours. So I don't know how this is going to be implemented, but I've never seen anyone with any real concrete knowledge. I mean, most times they have no idea what the attack vector was within 72 hours, let alone whether anybody's at risk. And you have to notify data subjects without undue delay if there's a high risk, which the regulators will determine there are. So here are the record-keeping requirements. Your contracts with other controllers of data, and if you use processors, the purpose of the processing, a description of the categories of data subjects and personal data, the categories of recipients that data will be disclosed to, transfers of personal data to a third country, time limits for the erasure of data, a description of the technical and organizational and procedural security methods, and proof of data subject consent to processing. If you have nothing else, you must have proof of data subjects' consent to processing. Fines for violations. This has always been the big headline with the GDPR. There's two levels of fines. One is for sort of speeding tickets, and one is for more like felonies. The speeding tickets are data protection by design, security, record keeping, breach notification requirements, the privacy impact assessment that you have to go through, and the requirement to have a data protection officer. You fail to do those, it's 10 million euros or 2% of your global turnover. The felonies are failure to get adequate consent, failure to get adequate consent for the processing of sensitive data, failing to honor data subjects' rights of deletion or erasure, privacy notice requirements, and data transfers to third countries if you don't have an adequate mechanism to transfer data to a third country from Europe, say to the USA. If you don't have that, that is up to 20 million euros and 4% of your global revenue. This, by the way, was borrowed from the antitrust regime in Europe, and if you know anything about that, it should be familiar. They look at the things you would expect to look at, or at least they're supposed to. Nature and gravity of the offense, the negligence involved, whether you mitigated damages, previous infringements, the degree of cooperation with your supervisory authority after you've been caught, and the categories of personal data affected. Obviously, the more sensitive, the more they care. A lot is unknown so far with respect to how this is going to be applied, and the Article 29 Working Party may be a phrase you've heard before. That is just a collection of the data protection officials in each one of the member states gathered together in one room, and they write opinions that say, basically, we hate everything. Then they don't tip. Well, anyway, they hate everything. We're waiting for them on some guidance about consent, little bit more granular guidance on consent, about the notice, what kind of transparency is required, and data transfers to third countries. The Privacy Shield, as you may have seen in the popular press, is under tremendous pressure. There are only two other alternatives. One is model contract clauses. They're being litigated right now. And then the other is binding corporate rules, which takes about 2 years and a couple $1 million to get approved across Europe. And so that's that. Just quickly on the e-privacy directive, it's being turned into a regulation just like the GDPR. It is going to require consent for any electronic communication service, voice, SMS, email, messaging, anything over the top, any electronic communication is going to require consent, the type of consent I described earlier. There is no opportunity, let alone opportunity to prevail, to argue that you have a legitimate interest and therefore don't need consent. Consent is required, is going to be required, at least on the current draft. It's being negotiated. They say that it'll take effect the same day as the GDPR. It won't, but it's coming. To wrap things up, some best practices. So you want to review your record-keeping systems and how you meet the record-keeping requirements, update your privacy policies and customer notice, and then really think hard about how you get consents and start considering your options for obtaining valid consents under the GDPR. Because if you get a valid consent under the GDPR today, it is valid on May 26, 2018, even though you got it long before the GDPR took effect. But if you got a consent today and it's not compliant with the GDPR, it is not compliant on May 26, 2018. You have to get it again. And you want to update your contracts with your service provider. So my time is up. I believe we'll have a little discussion, and then you'll hear from somebody else, and then you'll be done with lawyers.
Thank you. All right, so we'll take questions from the floor, but just to get the ball rolling, I mean, to the naive listener, this sounds like a stake through the heart of several sort of key players in the digital advertising ecosystem, in particular third-party data vendors, and less so perhaps for the walled gardens who are probably going to have an easier time managing first-party data.
Well, certainly the companies that have a first-party relationship with consumers have the opportunity to ask the question. Third parties have, turn around so I can see you people on my right. Third parties don't have the opportunity to even ask the question, let alone get the right answer, unless they have a contract provision with everybody who is they're getting data from. And that, these companies are very hesitant to change their privacy policies just for a single vendor, and it really puts third parties under a lot of pressure. And that's just the GDPR. When the e-privacy regulation comes about, and you are required to get consent for any kind of electronic messaging, that's a tidal wave for third parties. I look at the GDPR and I think this is a typical, it's just a huge hassle, and it has some really difficult things to do, but mostly it's a huge hassle. The e-privacy regulation is a catastrophe, because third parties cannot do it. It cannot be complied with in its current form.
Right. So at conferences like this, we spend a lot of time talking about different ways and innovations around tracking. We call it targeting, but on the internet it often is tracking. You do something in one place and you get served ads subsequently downstream as you're being followed around. is all of that impossible under
No,
this
no,
sort
no,
of thing?
not under the GDPR. That's profiling and automated decision making, for which there's notice and opt-out requirement, and so targeting is not dead, but the Europeans really don't like advertising, and they don't like targeted advertising even more. So even though it's a notice and opt-out, they're going to look, I expect that to be an area of focus.
With the big cloud vendors, the Amazons, Salesforce, Adobe, Oracle, the big vendors of cloud services, do they provide kind of one-stop shopping option for companies to go through, to basically provide compliance if you work through them, or
well,
is there?
So these are clients. So let's just take
Hypotheticals, okay.
companies, and say that Terry Kawaja was right when he wrote the Lumascape, I don't know, 10 years ago, and put little red dots around companies that had been acquired. He was trying to show there's a game of musical chairs, and if you want to make an acquisition, you better do so quickly because these companies are being snapped up by the big players. And it turned out he was right. Almost all the companies have little red dots, and Oracle, Adobe, Salesforce have bought them up. And they are trying to offer turnkey solutions, and I think it's safe to say that they're well aware of these regulations, and they're well aware that their clients want protection, and they're working diligently on it.
Yes? So the question was, in the context of tracking, what would be considered beneficial to the customer?
Yeah, so it's not quite that. The question goes to if for processing data, you can have either consent or a legitimate interest, provided that the balance tips in favor of the company versus legitimate privacy interests of the data subject. So I would say nobody knows what that means. We'll get guidance on that. I think there's a thumb on the scale to start in favor of the data subject. But I can imagine an innocuous retargeting ad for an innocuous product that isn't sensitive, potentially passing the test. Yes?
How do they plan to police this?
Well, it's been released, and
No, police.
police.
Yeah.
Police. Okay, so your data protection supervisor, which is the data protection authority in the company in the country where you have decision-making authority over data in Europe. So that's your authority. That country would initiate a enforcement proceeding under the GDPR, and they have come out collectively and said that there'll be no grace period whatsoever. I suspect that it could go one of two ways. They come out guns blazing, and the very first case is all the way, to the max, with the highest possible fine to get people's attention. It's not typically the way regulators work. Regulators typically bring some enforcement actions. They don't crush the company, but they do so to get the word out that we're on the beat. And then once they've done that for a little while, they get tired of people not complying, and then the hammer falls. But it would be your lead data protection authority, where that initiates the investigation.
Question from Dwayne?
Yeah, so I think that there are probably people here who are thinking, well, I'm not doing any business in Europe or not touching anything in Europe or making sure that my data is not going to touch Europe. Maybe some people are thinking, I'm going to make sure now that it's not going to touch Europe as well. But I think that the way that it'll impact most people in the room today, even if that's the case, is in the contracts that we sign with clients. Because those contracts are now going to have these provisions in them that are going to require compliance. And so I guess the question is, what's that going to mean for us in terms of how we then comply?
Okay, so what is us? Who's us? Right, so if you're an advertiser or a publisher and you're going to advertise into the EU or you're going to have a site that collects data in the EU, the vendor is going to have in its contract certain things that you've got to do, and you're going to require your vendor to comply with the laws, and that's just going to be the new paradigm. Is these contracts are going to specify requirements that meet the GDPR and the forthcoming e-privacy regulation, and because A, that's required, and B, you're going to need to have something to show a regulator that you took every available step to comply, including with the vendors that you work with or the partners that you work with. So it's going to be the new paradigm. You see this now with a lot of data security addenda that have grown in length over the last few years. It's going to be the same thing, but it'll be for privacy.
Yeah, I mean, a research vendor will sign a master service agreement with a large client, for example, like a Coca-Cola, or I'm not talking about that specifically, I'm just using it as an example. That master service agreement is going to be boilerplate to some extent. That will have provisions in it which will make reference to the European provision going forward. Even if you're not doing anything whatsoever in Europe and you don't have any touch points in Europe, the presence of that clause in the master service agreement is now going to impose that compliance with the European provisions in your contract. So
Yeah.
Even an American company that has nothing to do with Europe is suddenly going to get impacted by it if they have large clients who are going to be having that provision in the master
Right,
agreement.
that's true, and it's a good point, but it's a little bit of a tree that fell on the forest, because if you're right and you sign an agreement and it requires these provisions with respect to Europeans, you're not going to trigger it, and you're not going to get sued, and they're not going to seek an indemnity from you because you will not have violated the law. And so I expect there to be template agreements, and I expect there to be a lot of negotiation over those as we get a feel for this.
So the time is up, unless there are any other pressing questions back here, but why don't we thank Reid once more time, and you'll make your train.
Thank you very much.
Thank you. Okay, and with that, let's see what I'm supposed to remind you of. I know there's something other than to say thank you for a great conference, for great participation, for staying with us right through to the very final part, which I know is sometimes a temptation to skip. We do have a couple of slides to remind you of what I talked about earlier today, the upcoming events that you may want to attend. Member events in Chicago in July, in Bentonville, the shopper marketing event later in July, and then in Mountain View in November, the sort of extension of what we talked about this morning with Jeffrey Graham's presentation about big data and surveys and putting those together. And speaking of surveys, you will all be receiving a survey very shortly about this conference. I know you've been giving feedback, some of you through the app, but this will be your kind of comprehensive opportunity to give us feedback. And I really do encourage you to fill it out and help make the ARF great again. So thank you so much, and have a very fine trip home.
Come fly with me, let's fly, let's fly.